and I'll be very happy in the short time we have to answer any questions you might have. Thank you very much.
Professor Raj is going to be moderating the session, sir, and he will be taking the questions from the students who are putting it on the chat box, and we will take it one by one. Professor Raj, I request you to come in, please.
Good afternoon, sir. So the first question is by a person. He is asking, since you have talked about the Nuremberg trials, could you give us your opinion on the legality of the capture and further trial of Mr. Adolf Eichmann by Mossad?
Right. Well, I think from an international law point of view, the capture by Israeli secret service of Eichmann from Argentina was a contravention of law. It was clearly a contravention of the law of Argentina. Nobody can come into your country and my country and start arresting people, no matter what crimes they've committed. And the United Nations did recognize the Security Council of the United Nations recognized the illegality in international law of the arrest and really the kidnapping of Adolf Eichmann. Israel ended up apologizing to Argentina, and Argentina ended up accepting the apology. I think there was a realization that, having regard to the level of criminality of Eichmann, that it was a mitigating circumstance. But the answer to the question is that it wasn't legal. The court, the Israeli judges were faced with an application by Eichmann, who said, "Look, I've been illegally brought here. Release me. You've got no right to put me on trial." But the Israeli judges followed precedent in the United Kingdom, in the courts of England, and in the court of the United States, to the effect that it's not the job of judges to investigate how people come before them. If the person before them is the correct person, then they must put them on trial. I must say it's of interest that during the apartheid regime in South Africa, towards the end of that period, in 1989, a South African court was faced with that sort of situation. The South African police, the apartheid police, went illegally into our neighbor Swaziland, now Eswatini, and they kidnapped an accused wanted for treason. And he came to trial in Pretoria, and he took what's now known as the Eichmann defense. He said, "Look, I was kidnapped. I've got no right, you've got no right to put me on trial." And the trial judge followed the precedents to which I've referred, and he said the trial will proceed. The man called Ibrahim, he was an Indian South African, was found guilty and sentenced to a life in prison. He went on appeal to our Supreme Court of Appeal, and there 5 judges investigated the law under Roman Dutch law, which is our common law. And they held that under Roman Dutch law, a person who's been kidnapped into the jurisdiction may not be put on trial. And our Supreme Court of Appeal set aside the trial and ordered Mr. Ibrahim to be returned to Swaziland, where he'd been kidnapped by the police. So I think that gives you a very quick overview of the situation.
Right, sir. So the next question is, how does the ICC determine whether it has jurisdiction over a case or not if the crime is committed on the high seas?
Sorry, could you repeat that?
Yes.
Is it on the Q&A?
Yes, I've just published it. It is, how does the ICC determine whether it has jurisdiction over a case or not if the crime was committed on the high seas?
Oh, right. Well, you know, that is a good question, because the law of piracy is unique. Centuries ago already, the international community, members of the international community, decided that piracy was a unique case, because where crimes are committed on the high sea, there's no court of jurisdiction. There are no courts on the high seas. And they decided that for that reason, there should be universal jurisdiction for piracy. Universal jurisdiction means that it doesn't matter where the crime is committed. It means that for crimes subject to universal jurisdiction, the court of any country in the world has got jurisdiction. So if an act of piracy is committed in the Indian Ocean off the coast of India, that person can be put on trial in England or South Africa or Ghana or any other country under universal jurisdiction. This idea of universal jurisdiction was restricted to piracy, but in more recent years it's been growing, and it now applies to other international crimes such as genocide, slavery, and certain huge war crimes where courts can exercise jurisdiction. So, for example, the courts of France have recently and in the past put on trial people who committed crimes during the genocide in Rwanda. The crimes weren't committed in France, and the accused people weren't French, and the victims weren't French, but the French courts exercised universal jurisdiction.
Yes, thank you, sir. So the next question is that how do Scandinavian countries avoid corruption as they score consistently high in the transparency index? What is it that they do different in the Scandinavian countries?
Sorry, could you speak a bit more slowly? I have trouble hearing.
Right, sir. Sir, in the Scandinavian countries, what do they do differently that they have a very high...
Sorry, in which countries?
In the Scandinavian countries, in Sweden, Scandinavian countries, in Denmark, Sweden, what is it that they do differently that they have very low corruption?
So is this question on the Q&A?
Yes, sir. Yes, it's on the Q&A.
Well, there's a lot of questions here.
Sir, I'll repeat it again if you would like.
Can you refer to me on the Q&A?
Sir, it's in the published list in the third question. In the published list, third question.
Sorry, what number?
Sir, it's on number 3.
So I don't see it. Is it possible for me to deal with the questions that appear on the Q&A?
Right, so we can take the next question.
I see there's one question here from Advait. He said, you spoke about the difficulty in holding states which aren't members of the ICC accountable. Are there alternatives to the ICC to prevent war criminals from gaining impunity? Well, again, thank you. That's a very good question. There really isn't. The only way that war criminals can be brought to justice is in the courts of their own countries, or in an international criminal court, or in a country using universal jurisdiction. Now, universal jurisdiction is very seldom used, as I've said, and it only applies at the level of genocide and not to less, but even those serious war crimes. So there really isn't any serious alternative to the International Criminal Court. And of course, one important aspect too of the International Criminal Court is that its existence does encourage national governments to bring people to justice. If I can give you one example, the Security Council more than 10 years ago requested the International Criminal Court to investigate war crimes committed in Sudan, and particularly in the region of Darfur. And the International Criminal Court, acting at the request and under the powers of the Security Council, investigated it, and they took the bold decision to issue an arrest warrant against the president of Sudan, President al-Bashir. And the Sudanese government ignored the International Criminal Court, and to their shame, some even members of the International Criminal Court failed to arrest President al-Bashir when he visited their countries. Again, I'm embarrassed that South Africa was one of those countries that refused to arrest President al-Bashir. But it's amazing how the wheel turns, because since then, there was a coup in Sudan. President al-Bashir was put out of power. He's now in prison, and it may well be that the Sudanese government could still send President al-Bashir to trial in The Hague. One of his main collaborators, in fact, is now in The Hague. Recently, arrived in The Hague and is being put on trial for very serious crimes against the people in Darfur. He was the leader of the paramilitary group called the Janjaweed, who went on horseback and burnt villages and killed people in the crimes that were committed in Darfur, including genocide, with which President al-Bashir has been charged.